Good afternoon to everyone. Welcome and thank you for joining us today for what we hope will be an informative and certainly topical presentation at this particular moment in time. I'm Tim McCarthy. I'm a senior counsel here at Dykema, and I'm the leader of our international business disputes practice and also of our international trade regulatory group. Let's see here. Uh, just housekeeping and introductory matters. First, CLE credit is available for this. You can contact us at these coordinates. The recording and deck for this presentation will also be available for download after we're done. We're here together with not only the International Trade Regulatory Group at Dykema, but also with AIG, our automotive industry group. As a lot of folks, I think on the call know, for the entirety of its history, the firm has been devoted in substantial part to serving the needs of the automotive industry pretty comprehensively across a wide range of practices and evolving as the industry evolves. We practice nationally on behalf of the industry and other sectors, of course, as well. Recently, we have published our third automotive trends report on the back of surveys that we conduct with the industry and addressing interests of issues of particular interest in the industry at this time. Unsurprisingly, in that report and on the back of those surveys, a lot of interest in the subject matter of this particular presentation today, that being tariffs and trade regulatory matters. In about 2 months, we will be hosting our annual Automotive Industry Legal Summit at the M1 Concourse outside of Detroit. That'll be July 23rd. Really good event. We would be pleased to have you there if you could join us. I will be there. Tina will be there, and we'll cover, at that point, we'll cover whatever developments have then ensued in this area, as well as other areas of interest to the automotive sector. So beginning now, our speakers today are myself. I will just be emceeing. Most of the substance will be handled by my colleague, Tina Toma, and my colleague, Darren Chen. Again, as mentioned, I am senior counsel here in Dallas, Tim McCarthy. I practice in the areas of international business disputes, that's international litigation and arbitration, and also international trade regulation, with a focus on sanctions and export controls, but in the last couple of years, focusing more and more on tariffs and on the import side as well. Tariffs and the import side today will be covered by our colleague Tina Toma in our Bloomfield Hills, Michigan office. Tina is, particularly suited to help us cover this topic. Tina has previous experience on the business side in procurement and supply chain and in tariffs and trade regulatory compliance at a tier one supplier before she, made some kind of deal with some kind of demon and ended up being a lawyer and joining us here at Dykema. But she is a fantastic resource for us here. She, on a weekly basis, publishes video updates on the website, on our firm website, about that week's developments in the tariff and import side space. Definitely recommend checking those out to keep up to date. And then later in our session here today, we will hear also from my colleague and friend Darren Chen, who is sitting just down the hall. Darren focuses part of his practice on the export side, that is export controls, sanctions, and other export side trade regulatory matters, along with international business disputes and litigation. Darren and I are currently working, meaning the entirety of today, other than this 1 hour, on a substantial dispute here in Texas and in California in the autonomous vehicles space and artificial intelligence that also has some significant international aspects. So Darren is a particularly apt person to help us cover the export side of today's presentation as well. The subject matter of today's presentation is, as we all know, is international trade regulation at this particular moment in history, with particular focus, for today and here sitting here in mid-May of 2025 on tariffs and the import side. By way of background and some context, the title for the presentation today is The Third Quake, and that was my doing, and that is title that we gave this presentation a couple of months ago when we first set this up. Not a couple of months ago, probably about a month ago, when it seemed that what was going on in this space might be the third major economic disruption in recent decades to tip the global economy into recession. First two having been the global financial crash and the COVID pandemic. Now, 1 month later, and perhaps we should have anticipated this, it doesn't feel like it will, in fact, be the third quake on that scale, but that conclusion as well remains TBD, and that, of course, points to really the central feature of what everybody is dealing with in business and with regard to these international trade regulatory matters at this particular moment in time, which is a whole lot of uncertainty. International trade regulatory matters are first and foremost, or fundamentally, regulatory matters as opposed to legislative developments or developments in court and the development of the common law. And being regulatory matters, they are thus handled, subject first and foremost to the authority and the decisions of the executive branch. We now have a new administration in place that I think everybody agrees is taking a very different and new approach to these matters. Thus far, that new approach has manifested itself most saliently, most obviously, some would say, most troublingly, and presenting biggest challenge in the area of tariffs and on the import side, where we've seen a lot of activity, a lot of volatility, a lot of uncertainty, and a lot of questions as to how organizations are going to handle it and how we as counsel can help organizations navigate and manage their way through this time. In that regard, now we'll turn it over to our colleague Tina Toma in Bloomfield Hills. As I mentioned, Tina has substantial background in this space, and she's going to provide some background about how this stuff works, and then discuss what we've seen in the last few months and measures that can sensibly taken and other measures that sensibly you probably do not want to take to try to deal with these challenges. So Tina, please feel free, take it over from here.
Thanks, Tim, for that introduction. Good afternoon, everyone. My name is Tina Toma, as Tim mentioned, and just by way of further background, further introduction, I spent about 5 years in the automotive industry in procurement before law school, and that was through President Trump's first administration, so beginning of 2017 until I began law school in August of 2021. And I think there's what I like to call Trump 1 tariffs, right? So it was when we first experienced these tariffs in 2018, and just how we're all experiencing it today. There's various challenges, supply chain disruptions, pricing negotiations likely going on, and just that constant pressure to reduce costs. So when I went to law school, I really tried to focus my studies as much as I could on supply chain and tariffs, even wrote my law review article on it. And it was just a way to deepen my understanding of something that I had lived through professionally. And now as a lawyer, just got barred this past November. I combined that practical background with legal expertise to really help our clients navigate this ever-changing world. I've tracked these tariffs again since they began in 2017 or so. And my goal is always to just provide clear, actionable advice that helps manage these challenges. And so today I'll walk you through some key concepts, current developments on import tariffs that hopefully you guys can apply with your teams and to your business. So let's begin with the legal framework that governs tariffs. There are various authorities that empower the United States government to impose tariffs, and each are triggered by different circumstances and governed by various procedures. So the three that are in black are the ones that our current administration is presently using to implement tariffs. And these three in red, these are just something to be mindful of. It's additional authority, among other authority, that the administration has threatened to use tariffs. So, for example, Section 232 tariffs, we're seeing this a lot with the steel and aluminum tariffs we're seeing. And the Section 232 of the Trade Act is invoked primarily for national security concerns. So the president can invoke the Department of Commerce to begin an investigation. And there are times where public comment would be allowed. So industry leaders and other professionals can speak to the Department of Commerce and express their concerns. We are also seeing Section 301 tariffs, and primarily this is for China, for imports from China. And Section 301 of the Trade Act addresses unfair trade practices. And again, the president cannot unilaterally invoke this authority. An investigation needs to be commenced by the Department of Commerce in this situation. The United States Trade Representative, and there is a mandatory public comment period. So moving on to the procedural sequence, and this is how tariffs really do come into effect. So as we discussed, there'll be a trigger event. So we're seeing right now with China, there's concerns of unfair trade practices related to IP and various events. So at that point, legal authority would be invoked by the president. Again, there would be an investigation or report period, public comment, and then the president can take action based on the investigation and report of the USTR or the Department of Commerce. And then at that point, once he's decided and announced an action, it must be implemented via the Federal Register. And here is a overview of tariffs that we're currently seeing today. So so are you guys able to hear me? I'm seeing a little sign that says I have low connectivity.
Yeah, Tina.
Okay.
We can hear you.
Okay,
Yep.
just wanted to confirm. Thank you.
Mhm.
All right, so let's for imports from Canada and Mexico, tariff largely depend on USMCA compliance. So non-USMCA compliant autos will face a 25% tariff, and steel and aluminum imports generally face a 25% tariff, but certain exclusions do apply. So non-USMCA compliant goods can face a tariff as high as 50% or more. China, on the other hand, faces significantly higher tariffs, 47.5% on autos, 50% on steel and aluminum, and 30% on most other goods. And that's following recent trade tensions and a 90-day pause that was decided this past weekend between the US and China. And for the rest of the world, tariffs are currently sitting at around 25% for autos and steel, and a 10% general tariff on other imports, of course, excluding Canada and Mexico. An exception to note is the United States and UK trade deal, which sets a 10% auto tariff on the first 100,000 UK imports, and it will rise to 25% thereafter. Looking ahead, the Department of Commerce is currently conducting 6 separate Section 232 national security investigations. These focus on various products, including copper, semiconductors, lumber, pharmaceuticals, critical minerals, and trucks. These reviews may lead to additional tariffs. Right now, there's a planned 25% tariff on auto parts from Canada and Mexico that contain non-US content. And in response to these tariffs, several countries have implemented retaliatory measures. So China, for instance, imposed tariffs as high as 125% on certain US goods. These have been paused temporarily. They also have restricted exports of critical minerals and placed US companies on its entities list. And Canada has imposed 25% tariffs as well on the non-USMCA compliant autos and on $21 billion worth of steel and aluminum imports. And Mexico, the European Union, and Brazil have also announced retaliatory tariffs targeting US exports. So if trade negotiations that are currently ongoing between China, Mexico, and Canada fail, we can definitely expect further retaliatory actions from these partners and others around the world. And when planning this presentation, it was very important to me to really just give a good, strong legal background, because I know this is so new for so many. So a good starting point here would be the Harmonized Tariff Schedule, also called HTS. And this is a system that's used to classify imported goods for tariffs purposes. These codes will be a 10-digit numerical code, and they're organized by chapters, headings, and subheadings based on product type, material, and use. So the first 6 numbers represent the International Harmonized System, and that's the HS code, and that defines product categories globally. So you could see the system used with many of our trading companies, our trading partners around the world. And the last 4 digits are specific to the US and provide additional detail for determining duty rates and just tracking various stats. And all classification will follow the general rules of interpretation. This is also known as GRIs, which are applied in strict order, and that's to resolve any ambiguities. And this classification requires very detailed information about the product's specifications, composition, and intended use, right? So if you're shipping a tire in, this 10-digit code will differentiate whether that tire is being used on an automotive, on an auto, or is that being used on a tractor, or various uses. So, and this is something I think a lot of people might not know, is that Customs and Border Protection, they have an entire body that provides rulings, explanatory notes, and cross-references to help interpret challenging, or even there's borderline classifications, like, is this considered auto, or does this fall into a different territory? And we'll get into that a little bit more when we discuss the substantial transformation test. Before that, I just want to discuss some valuation basics. So tariffs are assessed on the declared customs value that is shown on the commercial invoice. And this invoice will typically include the invoice price, freight, insurance, duties, custom fees, and other related costs, and those are collectively referred to as landed costs. This is probably relevant to many of you. So intercompany transactions, let's say you have a German entity that is shipping to a US entity. There are some internal charges like management fees, research or development costs that may be excluded from the customs value, provided that they're not dutiable. So with this, it's important to know that if you guys do have a lower price for intercompany, that intercompany is reflected on that commercial invoice not only just the financial invoice. Also, the choice of Incoterms, which are just standard international trade terms, also affect valuation. So under FOB, also known as free on board terms, freight and insurance costs are excluded from the customs value. And in contrast, cost, insurance, and freight terms, also known as CIF terms, those are included in the valuation. So that would be the cost, of course, to cost, insure, and deliver the products. Right. And with the substantial transformation test, alluded to a little bit earlier, for each product that's being imported into the United States, the country of origin will determine where a product is considered made for customs and tariffs classification purposes. So what this test will do is it assigns origin based on where the product last underwent a significant change that resulted in a new and different article of commerce. So examples might include, to like paint a little picture, let's say that you are making an HVAC in China, and that HVAC is going to be shipped to Mexico and assembled into a vehicle. So the big question there is, did that initial HVAC undergo substantial enough change in Mexico to be considered a new product, a new article of commerce as it's imported into the US? And again, that will go to determining what the country of origin is. And really what Customs and Border Patrol is looking for with this is there a new unit that has a distinct character or use? So going back to the HTS codes, are you shipping a completely different HTS code now, or how has that number changed? And again, going back to the Custom and Border Patrol rulings, they have, hundreds and hundreds and hundreds of examples where importers will submit a request and just say, hey, Customs, Border Patrol, here's my situation. I'm currently shipping from China to Indonesia, Indonesia to Mexico. Here are the relevant changes that occur at each point. Has my product undergone substantial transformation so to be considered a product of origin from, let's say, Indonesia, that is not as heavily taxed, tariffed right now as, let's say, China per se. So what does not count as substantial transformation would be simple assembly, repackaging, or minor modifications that would not tend to meet that threshold for substantial transformation. Importantly, all importers, and it would be the importer of record. So if you have two parties that are working together to get a product on the into the United States, who is the party? It can only be one party, that's the importer on record. And they have the legal obligation to exercise reasonable care in classifying, valuing, and declaring their imported goods. US Customs and Border Patrol regularly conduct audits to verify compliance. Any material errors such as misclassification, undervaluation, or incorrect country of origin can lead to significant penalties under federal law. We're seeing a lot of, for example, like the Department of Justice is prosecuting under the False Claims Act. And I just wanted to throw this out there that there's this website, it's called ACE, and that is the website that importers use to input their shipments with the federal government. And they are able to see your entire import history. So if you have historically been importing product in from China for the last 5 years at a piece price of $50 per part, and China tariffs are now at 100, we're at 145%, and now those parts are, a tenth of that price. That is something they can very, very easily flag. Another something I've been hearing like on Reddit or reading on Reddit is people like rubbing off or scratching off the country of origin stamp from China, going into another country to restamp and ship that product into the United States. Again, they can look at your supply chain and your history and fairly quickly track that. And we'll get into a little bit about that later on. But penalties can range from interest only, and that's with valid prior disclosure, which we'll talk about in a little bit. And then to the full value, domestic value of the goods in cases involving fraud. Consequences can also include duty assessments, seizures of the product, material that's being shipped in, fines, and reputational or financial damages, of course. So a prior disclosure, it's a voluntary process that allows importers to notify Customs and Border Patrol of violations that involve false statements, omissions, or errors in import transactions. Filing a prior disclosure can reduce or even fully mitigate penalties under the customs regulations. However, this must be done before or without knowledge of any formal government investigation, such as Customs Border Patrol, ICE, or HSI. The disclosure should include a detailed explanation of the violation circumstances and corrective actions taken and payment of duties owed. And prior disclosure is considered a best practice to minimize exposure and really just demonstrate good faith compliance with customs laws. So you're not in a position where, the DOJ would prosecute you or your company for fraud. With that, I did want to just introduce, for those of you who might not know about customs brokers. It's my belief that to have the full picture and have successful trade compliance, there needs to be coordination between custom brokers and attorneys. Custom brokers are licensed by the Customs and Border Patrol Agency. They have to take a rigorous test that has an even lower fail rate than the bar exam, if you guys could believe that. But what they do is they handle the preparation and submission of entry documentation. Importantly, and most pertinent to many of you, is they classify goods under the HTS and ensure adherence to all of the procedural requirements. On the other hand, as an attorney, I will interpret the statute, and primarily right now what that involves is the presidential directives. So an executive order is published in the Federal Register or any declaration, proclamation, just really working to understand what that says and if there are any exceptions that may be of help to my clients. So we can support the classification analysis that the customs brokers do. And we also help with binding ruling requests. So let's say you have a situation and you go on the Customs and Border Patrol website and you can't find a ruling that is specific to your situation. We can request an assessment with that Customs Border Patrol just to make sure that, again, you guys are all 100% in compliance. We also represent importers during audits, disputes, and enforcement action. So again, best practice is really to align broker operations with legal review. We have partners that we work with internally that are well-versed custom agents. And they, again, will manage the operational side and will focus on the legal interpretation and together really just mitigate exposure to any risk. Next, I'm going to go through a few options for those of you that are interested in learning on how to mitigate the impact of tariffs. This is, I know legally there's not many exceptions right now, such as duty drawbacks that we saw during President Trump's first administration. But I always try to encourage my clients to see tariffs for what they are, and in my opinion, it's an opportunity cost. Um, we've been seeing tariffs for the last few years, but it's a once in a lifetime opportunity to really look at your costs, at the product you're purchasing, and ask yourself, am I overpaying? And I know resourcing, especially in the automotive industry, it's a very difficult task to accomplish. So I'm not suggesting that, but there are other value add activities that can be done throughout your supply chain to really, really, really optimize your supply chain and reduce costs significantly. My largest supplier that I worked with my previous employer, I felt the way many of you probably feel right now, where I was doomed and I, was looking at over $1 million worth of, which sounds like nothing with what we're seeing today, but at the time it was 10% tariff. It was over $1 million worth of potential costs. And I was able to not only avoid that $1 million, but also save my company $1.5 million. And they've been able to see that year after year after year, because again, I took it as an opportunity. So one option, which again, this is what I recommend most, it's tariff engineering. So what you do is you modify a product's design or composition prior to import to secure a more favorable duty classification. And importantly, that classification is based on the product's condition at the time of the import, not on its intended use after entry. And that was established by a Supreme Court case, Citrion, in the thing. Sorry, seeing that, notice that I'm losing connectivity. So can someone confirm that you can still hear
We're
me?
good. Still
All
good.
right.
Yep.
All right. So permissible tariff engineering will include commercially real product modification and non-deceptive design changes that serve valid business purposes. On the other hand, impermissible practices will include artificial or temporary changes made solely to reduce the duty, or designs that lack a genuine commercial purpose, which customs may treat as a disguise. And effective tariff engineering really does require careful documentation of what that business rationale, just in case there ever is a question. Again, customs goes on, that website, they notice, hey, this importer is saving like 20%. What happened? Why are their costs so much lower? Well, you can show them like we underwent XYZ, and we're able to save costs. Another option is temporary importation under bond, also known as TIB. And TIB allows goods to be imported duty-free if they are re-exported within a specified time frame, or they are used in the manufacturing of exported goods. So this program is particularly valuable for companies that are engaged in international manufacturing, or those that are operating with maquiladoras. Maquiladoras are foreign-owned Mexican facilities which assemble or manufacture goods for export to the United States. These facilities are very common, and they often qualify for preferential USMCA tariff treatment if the origin rules are satisfied. On a related note, bond warehouses are secured facilities where imported goods can be stored without immediate duty payment. And the duties are deferred until those goods are withdrawn, consigned from the warehouse for domestic use. And certain approved operations can also be performed while the goods are in storage. Again, those have to be pre-approved, so that could look like assembling a hose to an HVAC assembly or what have you. But to do so, importers should evaluate whether their goods and their business models qualify under the TIB program to benefit from the duty deferral. Next, Incoterms really do play a significant role in determining who bears the responsibility for customs duties. Many contracts assign duty responsibility to the importer under terms like delivery at place, DAP, or free on board, FOB. However, these can be renegotiated to shift duty liability. For one example, DDP, which is delivery duty paid, this term can place the obligation for customs, duties, taxes, fees on the seller. And this could help clarify who absorbs the cost of any future increases. Or you could also just have a contractual term, which we're seeing a lot of now, that just outlines in case of tariffs. This is the process. This is who will be paying for the tariffs. Next, there is the American Goods Return Provision, which allows duty-free entry of the U.S. manufactured goods that have been exported and returned without significant alteration while abroad. This provision also covers foreign goods that are returned within 3 years, provided that their value or condition has not been advanced or improved during that time overseas. Importantly here, importers must be prepared to prove eligibility to Customs and Border Protection, and that's to avoid paying the duties. And if duties are in fact, if they've been in fact repaired or improved, they may be owed based on the value of those modifications alone. And again, claims will require proof of US origin, such as country of origin markings or a certificate of origin. And also there's a very specific form that is needed for free entry. So for those of you that may have, I think this is particularly important with large injection molding tools. If you brought a tool in, did a modification in the US, maybe shipped it back to China for step 2 modification or another country, if that happened within the last 3 years, this could be a really good code as part of the HTS to use. All right. And that was the end of my presentation. So thank you all for your attention.
Thank you very much, Tina. And just to follow on Tina's discussion a little bit, as she laid out for us early on in the beginning of her portion of the discussion today, we have different species of tariffs being imposed, addressed on different tracks, so to speak. We have the reciprocal tariffs that are being imposed, withdrawn, continuing to some extent with regard to China under the International Economic Emergency Powers Act. And then we have the more traditional, the usual mode of imposition of tariffs by the executive under the Trade Act. Those are the Section 232 tariffs, Section 301 tariffs, so on and so forth. And those are moving forward on different tracks. And as we've seen in recent months, some of them get imposed and then perhaps paused or withdrawn, adjusted, so on and so forth. The Trade Act tariffs are now, for the most part, moving through the investigation process. So they're going to work through the flow chart that Tina laid out for us. The upshot of all this is that there's going to be continuing developments and continuing uncertainty in the space in the months and years to come. As a practical matter, as a compliance risk matter, that means we're going to continue to see some of the kind of things that we've been seeing in recent months, particularly in the relationship, the trade relationship between the US and China, where you have exporters who are offering, for instance, as Tina alluded to ship DDP. In that process, then they will make the declaration of value. Or other Chinese exporters offering to transship through Vietnam or Malaysia or another country with a lower tariff rate. And in that case, they will offer perhaps to do the certificate of origin, whether or not there's been substantial transformation of the goods in that transshipment, that third country. It's important to remember that if you're the importer of record on those shipments, you will remain responsible for any penalties that might be imposed for anything that another party in the chain might do. So those are not if if a counterparty in a supply relationship or a third party shipping company, logistics company shows up on your doorstep offering solutions that sound too good to be true, they almost certainly are too good to be true for the compliance reasons and because of the enforcement risks that Tina alluded to. And then the last really practical thing that I want to address on the back of Tina's presentation, her discussion, her astute and absolutely correct discussion of allocation of roles and responsibilities as between lawyers, customs brokers, and perhaps also your in-house logistics and supply chain and compliance personnel and professionals. That's getting those roles and responsibilities right is important not only for operational accuracy and compliance accuracy and thus legal risk, it's also important for cost purposes because lawyers cost more than brokers and brokers cost more than your in-house staff. And in a situation like the one that we appear likely to be in for quite some time to come, where you're facing continuing uncertainty, continuing changes in the picture moving forward, and issues arising on a pretty steady cadence as you move forward through this period. Getting those roles and responsibilities will be important for tuning your supply function and your supply chain and tariff compliance function. Again, not only for accuracy and risk management purposes, but also for cost purposes. And we'll just add one final pitch. Tina, unlike a lot of lawyers in the space, has that business side experience. And I know from experience here in the firm that she was really good at helping clients get that tuning of the process right. So with that, we'll turn to the second portion of today's discussion, which has to do not with the import side, but with the export side and with export controls and sanctions. This is the area in which I have been focused for most of my time, in which I've been practicing in international trade regulatory matters. And in the previous for quite some time, this has been the area that has seen a lot more activity than the import side because of the use of export controls and sanctions as tools of geopolitical influence and economic influence in previous administrations. It's been a popular set of tools for administrations to grab a hold of and try to use to achieve goals around the world. We're going to turn now to Darren Chen to address this half of it. The upshot I'll preview a little bit is that in the first few months of this current administration, we have not yet seen a whole lot of activity in this space certainly as compared to the import side, the tariff side. But as Darren is going to walk us through now, we can certainly expect activity in this space to pick up in the not too distant future. So with that, Darren, please take it away.
Thank you, Tim. Good morning and good afternoon, everyone, depending on where you are. As Tim said, compared to tariffs, not as much has happened in the world of exports yet, but we do know it's coming. And we know it's coming because this was hinted to us in the America First Trade Policy memo that the White House published back in January 20th. This was the same memo that laid the groundworks for the tariffs that we see now. Specifically, under Section 4C, the President ordered the Secretary of State and the Secretary of Commerce to work with other agencies to review the U.S. export control system and advise on modifications. At its face, it would appear that any modifications would focus on addressing strategic adversaries or geopolitical rivals. But the second half of this also orders the Secretary of State and Secretary of Commerce to, in their advice, address relevant national security and global considerations. And well, national security and global considerations is very broad. So at this point, we can only try to predict, but we don't know whether any modifications will be targeted or imposed broadly, such as with the tariff situation. And we do see hints of the administration's focus increasing in the area of export controls. Very recently, just this week, actually, the Bureau of Industry and Security published an update that the AI diffusion rule, which was actually supposed to go into effect today, has been rescinded. This was a Biden era rule that was set to go in effect today. And it was announced that the Trump administration is going to create a new rule that will address the same topic. For those of you that don't remember, the AI diffusion rule was the rule that categorized countries into 3 different levels. They're either allies, countries of concerns, or they fall somewhere in the middle. And based on that categorization, the export of US chips will be restricted. So based on what that notice said, though, it's hard to say whether the new rule will be less restrictive or more restrictive, or if it's just gonna be very similar. There were concerns with the old rule, the AI diffusion rule by businesses, that it would impact U.S. competitiveness in the chip industry, that it will push certain countries to buy chips from China instead. But all we can do now is wait to see what this more bold, inclusive strategy will entail. And of course, when there are changes to export controls, what comes is sanctions. And there are several countries that we're keeping an eye on in terms of sanctions. First, I want to say that not a lot of sanctions have occurred this year yet, but there are a few key countries that any exports controls would likely affect. First on that list is Iran. Back in February 4th, the White House published a memo called Restoring Maximum Pressure on Iran. This was to target its nuclear weapons development, its intercontinental ballistic missile development, and its terrorist networks. So we have saw some sanctions on entities engaged in the Iranian petroleum trade. And this does not affect just buyers and sellers, but any entity involved. There have been sanctions on ship management companies, on cargo inspection companies. Right now, if you're, I don't believe any of you are, but if an entity is engaged in Iranian petroleum products trade, you are highly at risk, especially because the US is very much interested in brokering a nuclear deal with Iran now to ensure that they never ever develop nuclear weapons. Of course, China will always be a big topic right now. There's a big talks about China-US tariffs. On the export and sanction side, not much is happening so far. What we do know is that at least when it comes to AI chips, if there are any new rules, new export controls, China will likely be the most heavily targeted, as they're developing their own AI chip industry. And then there is Russia. The Trump administration has not imposed any new sanctions so far on Russia. There have been pressure on the administration to impose sanctions, such as on its banking and energy industry, due to the ongoing Russia-Ukraine war. And on the latest news, President Putin of Russia did not show up to Turkey for peace talks today. And so there is going to be an increasing pressure to impose sanctions. However, whether it happens or not, we don't know yet. When it comes to geopolitics, a lot harder to predict the future. But there is some positive news. So it has just been announced that after 45 years, President Trump has ordered that he will be lifting sanctions on Syria. So these sanctions have been in place since 1979. And what this means is that there is going to be a new market for exports. I can't say Syria is a big market, but a market is a market. But more importantly, what this signifies is that in a world of grim news is that any modification to export control systems might not all be about tightening of restrictions and more restrictions. This lifting of sanctions on Syria kind of somewhat signifies that there could potentially also be loosening of restrictions in certain areas where maybe the administration views that the U.S. needs to be less concerned about, such as like not less strategic areas or areas where we're not competing as heavily with certain countries. And so, as I mentioned, there isn't a whole lot of news in the export controls and sanctions world right now, but do keep an eye out. It's been hinted already, and it looks like the administration is giving it more attention. So, yeah, with that, I'm gonna turn it over back to Tim for some additional remarks.
Yeah, thank you, Darren. So just to wrap up that second half of our discussion today, the shorter half by design, because as Darren rightly indicated, thus far in the new administration, we're 4.5 months in, there hasn't been a whole heck of a lot of additional activity in export controls and sanctions. But as Darren indicated, we definitely expect that there will be. An interesting development, apropos of Darren's last point there, is that unlike previous administrations in which these measures tended only to ratchet up, there are some indications thus far that there might be some significant loosening of sanctions, sanctions in particular, that we might see some significant instances of sanctions being pulled down. That's of interest to those of us who have practiced and worked in this space, because for quite some time, there's been a lot of discussion at sort of a high level at a policy level, about whether or not the U.S. has been essentially bumping up against the ceiling of what can be achieved with sanctions. We're still finding ways to sanction new particular parties new particular Iranian parties, or parties connected to Iran as their sanctions evasions measures evolve and change over time. But you would be hard pressed to find any economic activity involving Iran that has not yet been sanctioned. There's not a whole lot left to do there. And so the possibility that in this administration we might see some meaningful sanctions coming down is interesting in itself. It's also interesting from a business perspective, because we're talking about a couple of substantial markets here, particularly with regard to Iran and Russia. Given the history of sanctions and the history of restraints upon trade and economic activity with these countries, and particularly with Iran, the size of that market and the potential of that country, and also of Russia, certainly to be players in the global economy, I think is perhaps a little bit underappreciated. Iran is over 80 million people. It's a country geographically the size of California, and in terms of population, twice the size of California. Russia, prior to its invasion of Ukraine and the imposition of global sanctions against Russia, was the 11th largest economy in the world. These are potentially substantial and consequential players in global markets and could present substantial opportunities. When the JCPOA, the previous nuclear deal, was in place, and substantial trade was allowed with Iran, you still didn't see a whole lot of direct activity as between the U.S. and Iran because of sanctions and measures that did remain in place, and because of political positioning even within Iran. That is to say, Iran taking measures essentially to discourage, and non-legal or extra-legal measures to discourage economic activity as between Iran and the U.S. But there was a lot of activity even with the foreign subsidiaries of major U.S. concerns. So in that window where it was possible, activity did start to pick up. And then as between Europe and Iran, it picked up, very substantially, and then was shut down again when we stepped away from the JCPOA and reimposed sanctions. Russia, obviously, big player in the petro markets, and a substantial market for Europe and also for U.S. products prior to its invasion of Ukraine and the imposition of sanctions on the back of that development. So, we certainly expect additional export controls to be imposed. We're going to see what happens with sanctions. Things might move in a different direction with sanctions. And then particularly with regard to China, there is another trend ongoing in sanctions and export controls around the world, and that is what appears to be the beginnings of a fundamental shift in how those measures are used, and the ways in which that activity flows. For a long time, pretty much the U.S. decided what sanctions to impose. The EU, perhaps the UN, would slipstream behind, and other partners, Japan, for instance, would slipstream behind what the U.S. was doing. And that was pretty much the picture, right? The U.S. and the West were imposing sanctions on other countries around the world. In recent years, you've seen other countries imposing sanctions and export controls back toward the U.S. and the West, particularly China recently with regard to critical minerals. And I would point out also that other suppliers of critical minerals around the world, including African countries that don't even have very substantial trade regulatory regimes, across the board, have figured out that they do want to impose export controls on critical minerals. So, again, additional complications that appear to be coming down the pike. We're sitting now here at 12:59. We did not make provision for Q&A in today's presentation, but all three of us, of course, stand ready to address such questions as you might want to send to any or all of us at these coordinates that you see on the screen. And again, of course, if you need to follow up with us regarding CLE credit, please do so. And thank you again for attending. It's an interesting area. It's a fun thing to talk about. Not necessarily so much fun for organizations to deal with, but we're here and we're pleased to help when and as we can. All right, so thank you very much, and have a good afternoon.
Thanks, everyone.